Would you care to reflect on your time as clerk of the Privy Council? You served a prime minister who was found to have broken the act that we're studying, and twice.
The fact that you can't even answer that, I find really astounding, and it really raises the question in my mind of whether you're coming here in good faith to answer questions. Now I will ask you this, and I hope you'll agree with this, that when we're talking about the Prime Minister's ethics screen, it's extensive. It's unprecedented. 103 different companies, 103 different conflicts of interest, 103 ethics screen, right?
And I don't think it should be intent of the ethic laws to prevent people who are successful in their life as businessmen to be excluded.
They'll step out for that item.
And is there a practicality? Is there a practicality issue when the minister in question is the first minister, and these are like massive concerns or massive issues that are being considered?
This guy's garage. Like and subscribe.
Welcome to meeting number 11 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. The committee is resuming its review of the Conflict of Interest Act.
I would like to welcome our first witness for the first hour today. As an individual, Mr. Michael Wernick is here.
Mr. Wernick, when you were clerk of the Privy Council, you oversaw compliance of the Conflict of Interest Act. Would you say that the existing divestiture provisions, including the use of blind trusts, actually prevent conflicts of interest, or in practice, do they or can they fall short?
I think this is probably one of the central questions the committee will want to come to a view on. If you'll just permit me, I saw the conflict of interest regime as one tool in a broader toolbox about democratic governance, and there are a number of tools designed to detect and deter inappropriate points of leverage on our decision makers and keep the trust of Canadians. So very briefly, the Lobbying Act, the rules around campaign donations, the Foreign Agent Registry, security clearances, criminal code provisions. This is all helped by a beneficial ownership registry, a lobbyist registry, and transparency around government contracting and contribution agreements. Parliament created the commissioner model, and it provided for a range of remedies at the discretion of the commissioner, and one of them is a trust arrangement. So I think it's up to you to judge whether it falls short or not. I would keep it in the toolbox.
Would you say that it's effective for people who report to the Prime Minister to be the ones ensuring that the Prime Minister that they report to is not in violation of the Act?
Well, it's ultimately up to the Commissioner to make rulings on that.
To make rulings on whether or not the people who report to the Prime Minister should, for example, administer a blind trust?
No, correct me if I'm wrong, but if the arrangements that any Prime Minister or Minister or office holder would make would be discussed with the Commissioner, and the Commissioner would exercise an opinion on whether they're adequate or not, can request changes and has remedies available to him or her.
Based on your experience, do you think that that works?
I think that it's going to be tricky when people come into a background, extensive background in the private sector. People come into Parliament, as you know, from many, many different backgrounds, and we want, I think one of the other purposes is to ensure broad and inclusive participation in public office. I would be very careful considering mandatory divestitures because it may end up as a deterrent to people with a private sector background coming into politics. And my view is that we need more people with private sector backgrounds in politics, not fewer.
I guess the issue is that it's a question of public confidence. Canadians being able to trust that the system that's in place is adequately ensuring that there is no conflict of interest. And in the case of an individual entering office, being elected, serving as Prime Minister, having significant investments and those investments going into the blind trust, and the ethics commissioner telling us that there's not any really a lot of churn of those investments, they know what's in there. And then the conflict of interest screen is administered by direct reports to the Prime Minister. And the perception can be and is that there's a conflict, and that a Prime Minister is continuing to take decisions that further their own financial interest. And there's no reporting to the public on when a conflict of interest screen has been triggered and if it's ever been triggered. And so the higher imperative, I would say, or the leading imperative is that we ensure that Canadians have confidence in public office holders and public institutions, and they don't seem to have that. Would you care to reflect on your time as clerk of the Privy Council? You served a Prime Minister who was found to have broken the act that we're studying, and twice found guilty of breaking that law. 10 different instances, and that's based on the regime as it currently exists. You must have some suggestions on improvements so that we can avoid a situation where we find a Prime Minister who is repeatedly breaking this law.
You have a minute, Mr. Wernick. Go ahead.
Sure. Well, I think we should discuss this further because the law is built on language which includes perceived conflict of interest. And I think that's always going to be a challenge because perceived conflict of interest can be very subjective. And somebody's going to have to exercise judgment about what is a perceived conflict and what are the appropriate remedies. Certainly you can change the Act to add other provisions, more sanctions, and so on. But I think the problematic part of enforcing the Act is that somebody's got to exercise judgment and discretion about perceived conflicts of interest.
In the case of Mr. Trudeau, though, it wasn't a perception; it was that he actually broke the law, and it would seem that. Well, I mean,
sorry, but you're conflating broke the law with an infraction on a perceived conflict of interest. There are many ways to break the law. Yeah, of course. But there are different remedies. Sure, but there are different remedies and sanctions available to you. Okay. And I think the committee might want to review the the array and the ladder of sanctions available.
Mr. Poliver, as a leader of the opposition, do you think it's correct that he still does not have a security clearance? And is it ethical for a party leader to keep getting a security clearance?
Well, I don't want to get drawn into partisan crossfire, but I have said publicly that I do think all party leaders of parties recognized in the House of Commons should go through security clearances, largely to do with foreign interference. But in the context that we're talking about today, going through a security clearance will reveal potential points of leverage on someone. It will reveal credit issues, financial issues, personal conduct issues, business contacts, relationships, encounters with the criminal justice system, and so on. So in fact, one of the most practical ways to deal with perceived points of pressure on decision makers is to ensure they've had a security clearance.
Thank you. In your testimony, you also mentioned there are criminal situation which can be if a minister or a prime minister is in conflict. There are criminal because I understand that one of the senators who was charged criminally because he wasn't acting in the right interest. Can you put some light on that?
Well, there's a whole section of offenses in the criminal code. If I recall, it's section 121 about influence peddling and bribery and fraud and misconduct by public office holders and officials. There are sanctions on people trying to bribe politicians and sanctions on politicians that accept bribes, just to use one example. The criminal law is its own sort of world with very high standards on burden of proof. You're innocent until proven guilty. It has well-established rules of procedure and evidence that is a higher bar than the one Parliament has given to the various commissioners and officers of Parliament. Parliament has allowed commissioners to stray into things that are not criminal offences, but may be important. And so that's why you have the Lobbying Act and the Ethics Act and the Conflict of Interest Act. And the standards of evidence and the standards of procedure are quite different than a criminal court.
In some parts of the world, they call themselves democracies, but to vote, you have to be a landlord or you have to have certain assets. In Canada, every Canadian, doesn't matter their background, whether they are from private background, doctors, lawyers, they are all entitled to. And I don't think it should be intent of the ethic laws to prevent people who are successful in their life as businessmen to be excluded. I would like to hear your view on those.
Well, you might want to consider looking at a preambular language to the law and making the intent clear to the courts and others that the intent of Parliament is to encourage the widest possible participation of Canadians in public life, and this applies both to partisan politics and to the public service. But that has to be balanced with the issues that raises, and therefore a Conflict of Interest Act and a Foreign Interference Act are important counterweights to that.
You have served that position as a Privy Council chair. How do you think you compare Canadian ethics law to the rest of the world that, especially the Western world, that we compare ourselves from time to time?
Well, I would commend to the committee a couple of papers that are done by the OECD, that's the Organization of Economic Cooperation and Development in Paris. They have 34 members, countries, and they have a public governance secretariat. They have done comparative reports on conflict of interest legislation. I sent a link to the committee chair, the committee clerk earlier this morning. What they say is that we're not the very best, especially on some issues of enforcement, but we're respectably near in the top sort of quartile or so of the 36 member countries. There are different countries take different approaches to what's included and what's deemed and what the sanctions are. And I think Britain is a good example. Australia is a good example. The provincial regimes in Canada are a good example. There's probably a lot. I would commend to the committee to try to find somebody from the OECD Public Governance Secretariat to talk to.
Mr. Wernick, I want to ask you a few questions about the Prime Minister's ethics screen. Would you agree that in terms of seeing that it is triggered, that requires an exercise in judgment that is subjective by those who are responsible for administering the screen?
I'm not sure I understand your question.
Well,
the onus is on a public office holder to provide information to the commissioner. It happens all the time.
No, I'm asking you, you earlier spoke about perceived conflicts of interest, and you specifically said that requires an exercise in judgment on a subjective matter. Now, we have a Prime Minister's ethics screen that states that Mr. Carney may participate in discussions and make decisions affecting 103 companies on matters that affect the company's interests as a member of a broad class of persons unless those interests are disproportionate to other members of a class. Now, I would note that this language of having a disproportionate interest doesn't come from the Conflict of Interest Act. It's a subjective question. It's a subjective test, isn't it?
Yeah, and I'm totally comfortable that that's a job that Parliament assigns to the Commissioner.
Well, the Parliament did not assign that language. That was something that was incorporated into this screen, and I would note that this language, have you seen this language in an ethics screen before? That specific language of a disproportionality test?
I think Parliament has given the Commissioner the mandate to make these judgments about what is the appropriate arrangement.
I understand we have an ethics screen in place. I understand the process that led to the ethics screen. I've just asked you a very straightforward question. It should be obvious But yes, it is a subjective test. Yes, it is a subjective standard. And the fact that you can't even answer that, I find really astounding, and it really raises the question in my mind of whether you're coming here in good faith to answer questions. Now, I will ask you this, and I hope you'll agree with this, that when we're talking about the Prime Minister's ethics screen, it's extensive. It's unprecedented. 103 different companies, 103 different conflicts of interest, 103 ethics screen, right?
Sorry, what's the question?
It's pretty extensive, isn't it? Unprecedented.
Yes, it's the most extensive private sector record since Paul Martin.
Well, thank you for providing, for the first time, a straightforward answer to a straightforward question. Now, given the fact that it is an extensive ethics screen, unprecedented, as you've conceded, Canadians have serious concerns about, frankly, the lack of transparency around it, to see that it is triggered when it ought to be triggered. And you served as the clerk of the Privy Council. As clerk of Privy Council, you were pretty busy on a day-to-day basis, were you not?
Mm-hmm.
Yeah, so can you explain to me how it is that this is being left to the clerk of the Privy Council and the Prime Minister's Chief of Staff to administer? How can Canadians have confidence that the screen is being triggered appropriately? Would you agree that there is a legitimate basis for some concern in that regard?
Well, if the committee wants to recommend disclosure of all the instances when the screen was invoked, go for it.
Well, and that's one of the problems that we have, is that right now we have no idea when the screen is invoked or not. One witness came and said that really all we have is hope and trust. Do you think hope and trust is sufficient?
No, I have my faith in the commissioner.
So your answer is that you're satisfied that hope and trust is sufficient, because that's what we have with this ethics screen.
No, those are your words, Mr. Cooper. I think Parliament has given the job to the Commissioner to make judgments about the appropriate screens and the appropriate sanctions.
Yeah. Well, I certainly don't have a whole lot of trust and confidence that it is being triggered appropriately. Would you support amending the Conflict of Interest Act to provide for an enforceable general anti-avoidance measure so that anyone who circumvents the Act by circumventing a technical loophole would be held accountable?
I mean, that's a question for lawyers. It would have to be linked to whatever the sanctions are for an infraction, but that's used in other laws, and you would. I don't see any problem considering it for this law either.
What sort of guidance, training, or ethical code or oaths are you privy to as a senior member of the public service that would guide how you would look at a situation where you were responsible for being part of managing a screen, for example?
Oh, well, I'm not going to be exhaustive, but you have all of the training that goes into all the jobs you had before you were promoted to that level and the cases that you would have dealt with. There is a guidebook which you're familiar with called Open and Accountable Government that was first made transparent by Prime Minister Harper and has been made transparent by Prime Minister since. There's a fairly detailed infrastructure of training for senior officials and deputy ministers in specific issues. In most big departments, you have a legal services shop. You have people you can lean on for advice on specific issues. In the Privy Council office, which is the sort of secretariat for Cabinet and its committees, there are people in the legal shop and in the Cabinet operations shop who are very well trained and familiar with the case law and the practices and the examples that have come up. And you do end up leaning on them for advice. But I can assure Canadians that those, that's a responsibility taken very, very seriously. It is part of the role of Secretary to Cabinet, an office which has existed for centuries. And I'm not sure there's any other way to do it.
And maybe just practically speaking, how would a clerk or a deputy minister give effect to a conflict of interest screen? So what procedures have you either implemented or seen implemented around you to to make those screens effective?
Well, overwhelmingly, the business of cabinet comes in as proposals from ministers. So you have to start at the departments, in the ministers' offices of people that are making pitches to cabinet through cabinet documents and papers. So they should be attuned to flagging and identifying any potential conflict issues if the minister has screens. And then you have on the receptor side at Privy Council office and its various teams, there might be 200 or 300 items come in a year. And if you know what the screens are, you can simply, look for them. If it's a shipbuilding case and you own Canada Steamship Lines, it's pretty obvious. Those sorts of things. So I think it does get into the area of, how clear is it, as opposed to a perceived conflict that there might be some second or third order effect. But you have people that are trained and expert in this issues and accumulated experience, in exercising this function. And sometimes you would recommend, I think the minister here should go and talk to the commissioner.
And there's a notice of screen, presumably, that is circulated at times as well to inform people in and around the department about a screen?
My recollection is that people are aware of what the specific screening items are, and they are able to create a kind of a radar system for them. I don't know how it's implemented these days, but
you mentioned that there's many tools in the toolkit here. Is there any merit in your mind to bringing the conflict of interest code for members of the House of Commons to the same standards as those on a public office holder under the Act?
I think that's a judgment you'll have to make. I mean, you certainly have an influence. You're one Canadian in a million who actually gets to write laws, so you do have an enormous amount of power. I actually think it probably is the Lobbying Act that needs to be upgraded, because there's a lot of lobbying of MPs and senators that's not caught.
Thank you very much.
If there's a potential conflict that's flagged, what's the evaluation process? What does that look like?
I'm not sure about the details. I mean, I think what happens is that items that come in are referred to specific secretariats. It might be economic, social, foreign policy, indigenous affairs, or whatever. And you have an assistant secretary, sort of an ADM level person, sorry for the jargon, and they will be looking at items coming in. Most items arrive, after several rounds of interdepartmental meetings, people from the sponsoring department coming to PCO. So you don't get very many cabinet items that arrive without prior notice, and there is some time for people to take a look at the screens and see if something needs to be actioned.
And who recommends the decision that something not? Let me rephrase. Who makes the recommendation, and to whom would they make the recommendation that the screen be invoked? And so that's something that was going to go before cabinet, not be presented with the affected public office holder being absented from the room, I guess.
Yeah, I'm not. I can't tell you for sure how it's actioned now. I left several years ago. Most cabinet business is done at committees, chaired by other ministers. So my recollection, and I stand to be corrected by people from Privy Council office, is that it would have been the assistant secretary, who's basically the secretary to each cabinet committee, and in the case of full cabinet, it is the clerk.
And so, at the end of my last round, we talked about the effectiveness of having the chief of staff or having the clerk of the Privy Council, who both serve at the pleasure of the Prime Minister, responsible for ensuring that that the Act isn't violated. They're the ones that are advising or protecting against this from happening. In the case of Mr. Trudeau, it didn't work. And in the case of Mr. Carney, he's got 103 potential conflicts that are flagged, and we're left with the same system, and it's left in the hands of these individuals. Now, look, they both can be long-serving and well-regarded. But the problem is who their boss is and what their function is to prevent the conflict. And in this case, the risk of a decision being made by the Prime Minister that could further his own financial interests, this goes to the heart of the erosion of confidence that Canadians have in their public institutions. Do you recognize that there is a weakness in this system?
I mean, I think you could tell the story of the last Parliament that all of those issues were detected and made public and became a subject of parliamentary discussion or investigations by the Commissioner. So at some level, the system is drawing out those issues. I don't think you can describe potential issues of perceived conflict in the future in a way that can really be legislated for with a lot of clarity. There's just too much subjectivity.
You mentioned that there's a process in place that prevent the items from ending up on the agenda or flagging them for cabinet committees. So the record keeping and the note taking exists. Should the law require public reporting of when the screen is invoked, it wouldn't require a great lift of the...
is rarely take the item off the agenda, it's recusal. So if there's a minister in the room that may have a perceived conflict, they'll step out for that item. And
is there a practicality? Pardon the interruption, a very short time. Yep. Is there a practicality issue when the minister in question is the first minister, and these are massive concerns or massive issues that are being considered?
Yeah, as I said to a previous question, I have no objection or problem with you writing specific rules for the Prime Minister's office, given that the Prime Minister plays a particular role, in cabinet. And I have no problem with your suggestion, but what I would suggest is that those invocations of the screen be disclosed to the Commissioner. And the Commissioner can come to a view what they want to do about it.
Okay, thank you, Mr. Wernick.